I'm taking the session on the topic Human Rights in Women, Understanding and Analysis. So without any further ado, let's move to the session. So this session will be dealt in a threefold manner, with firstly, what is sexual harassment? Secondly, the Vishaka Judgement, and thirdly, the application and scope of the act. So let us move to the first thing. Now, what is sexual harassment? So I think this is a very frequent term regarding what is sexual harassment, what is the definition of sexual harassment, what acts constitute sexual harassment. So let us look into three legislations, namely the IPC, the newly enacted BNS, as well as the POSH Act. So under the IPC, Section 354A defines 4 acts which define sexual harassment. So it means physical contact and advances, demand for sexual flavors, showing pornography, making sexually colored remarks, and all the likes. So the punishment is also specified herein. And this is what the IPC says about sexual harassment. Now moving on, what does the BNS say about the sexual harassment? So right now we are saying about the BNS. So what does BNS say? Now we can see that the BNS is very similar. I mean, it is exactly similar to the IPC with regards to defining sexual harassment. The only difference here is that the sections has been slightly changed. So here also, sexual harassment is consisting of 4 acts, and the punishment is also the same. So now let us have a side-by-side analysis of what sexual harassment is in IPC and BNS, so that it will be crystal clear to all of you. So you can see that we have a comparison between IPC and BNS regarding sexual harassment. So here the essential element is for both of them is that here only a man can sexually harass someone. So here also sexual harassment is defined with respect to a man. A woman cannot be accused of sexual harassment in both IPC and BNS. In both the legislations, the gestures or acts which constitute sexual harassment is the same. Physical contact, then demand for sexual flavors, showing pornography and making sexually colored remarks, and the punishment is also identical. So we can say that even though the new law has come into existence, the constituent or what constitutes sexual harassment is same for both the laws. And if that is clear, I'll move on to the POSH Act. So now the POSH Act. The Section 2 Clause N of the POSH Act defines sexual harassment. So here, it is essentially the same as what is defined in the IPC BNS. So you can see it is a physical contact or advances, a demand or request for sexual flavors, making sexually colored remarks, or showing pornography, any other physical or verbal or non-verbal conduct of sexual nature. So we can see that in India, all the 3 legislation which govern sexual harassment define it in an identical manner. However, the only difference is that in POSH Act, while defining sexual harassment, they have not said it is by a male. A man is not clearly defined in the POSH Act. So that is the only thing that distinguishes POSH Act from the IPC and BNS. So if that is clear, let us move on to the next segment of today's seminar, that is the Vishaka Judgement. So how many of you have heard of the Vishaka Judgement? Can one of you please answer me? Let us make this session a bit more interactive. One, tell me what you understand by the Vishaka Judgement.
Ma'am, it is a 1997 judgment by the Honorable Supreme Court, whereby the 2013, as a result of this judgment only, the the 2000 Act of naming POSH Act came in existence.
Okay, thank you so much. That too is very useful. Just a second, let me admit the participants in. Okay, thank you. So thank you so much for that interaction. So now let us understand what the Vishaka Judgement is. So here, you can see a brief overview of the Vishaka Judgement. That is this name of case, the citation, the name of the court, the petitioners, the respondents, the bench. So you can see it was a 3-member bench with Chief Justice J.S. Verma, and the judgment was passed on 13th August 1997. So this is an overview about the Vishaka Judgement. Now, yeah, I hope all the participants have been let in. So now we'll move on to the next half. So what is the background of this Vishaka Judgement? So the background is basically that, firstly, we have Banwara Devi, a woman who belonged to Rajasthan. She was working as a satin, And in 1987, she took the issue of an attempted rape of a woman, and that was very successful. All the members of the village gave her full support. However, in 1992, she took up another issue based on child marriage. However, we can see that child marriage is something that is deeply ingrained into the custom and psyche of the people. So obviously, it was met with a lot of resistance, and almost all people who were supporting turned against her. So what happened? Everybody in the village turned against Banwari Devi, and meanwhile, the family of one Ram Karan Gurjar had made arrangements to perform the marriage of his infant daughter Ban. And then what did Banwari do? She was a uh, very conscious lady, and she attempted to persuade the family not to go ahead with the marriage. However, all the attempts were futile, and the family decided to move ahead with the marriage. So this is one half. Now what happened next? On 5th May, Banwari Devi, along with the other officers, what did they do? They went and interrupt the marriage because the family was not obviously listening to them, and they went and interrupted the marriage. So what happened? Banwari Devi had to face a social boycott since she included the law enforcement agencies. So as we can see, Banwari Devi was facing a severe social boycotting. Now, on September 22nd, 1992, the five men of the above mentioned family, they attacked Banwari Devi and her husband and later brutally gang raped her. Okay, so this is the cause of action for our current case, which is the gang rape of Banwari Devi, who was performing her duty by five men who were angered by her actions. So now what did the police do? Banwari Devi obviously filed an FIR report, and however the police were very reluctant to take case, and they did not take any sort of an action, and there was a delayed investigation. However, despite all these criticisms, Banwari Devi, with her incessant determination, managed to file a report. But the medical examination was delayed for around 52 hours, and the examiner did not mention any commission of rape in the report, but rather mentioned the age of the victim. So now, what happened next? We can see that in the absence of sufficient evidences, all the accused managed to get acquittal. However, this acquittal resulted in a very huge backlash from women activists and organizations who supported Banwari. And the net result is that they came together under the aegis of Vishaka and filed a PIL. Okay, so this PIL was filed under the aegis of Vishaka, and it laid focus on the enforcement of the fundamental rights of women at workplace. So this is what laid down the spark for the POSH Act. I hope the background of the POSH Act is very clear, and now we'll move on to what actually the judgment said. So there were three issues raised in the Vishaka PIL. So firstly is whether sexual harassment at workplace amounts to violation of gender inequality and right to life and liberty. Secondly, whether the court could apply international laws in the absence of applicable measures under the existing laws. And thirdly, just a second, yeah. And thirdly, whether the employer has any responsibility when sexual harassment is done to or by its employees. So you can see that these were the three major issues that were raised. So right now we can see the Vishaga guidelines. So you can see that as the aftermath of this judgment, the court laid down a set of rules which came to be known as the Vishaga guidelines, which are supposed to stay in place unless the legislature enacted a competent piece of legislation for the same. So we can see that the Vishaga judgment consists of 12 guidelines which were laid down by the courts, which stayed in place from 1992 till 2013, wherein the POSH Act was enacted. So let us look into what are the Vishaga guidelines. So firstly, it is a duty of the employer. So the court lays down that it lays a duty upon the employer and other persons who are responsible to ensure that sexual harassment do not take place. Secondly, it defines sexual harassment, and this definition of sexual harassment has been incorporated into all the acts. We can see that the definition in IPC was brought in. It was brought in by the Criminal Law Amendment of 2013, and that definition is exactly the same which has been defined in the Vishaga guidelines. So that is definition part. Third is preventive steps. So all of us know that prevention is better than cure. So the employer has obviously has the duty to prevent sexual harassment from happening. The fourth point is criminal proceedings. So with respect to criminal proceedings, if the employer or any persons concerned are aware of the fact that such and such instance of sexual harassment has taken place, they are bound to initiate the criminal proceedings or whatever criminal law enforcement actions are to be taken. So these are the first four. Next, we have, yeah, I hope everyone is in the session. So next, we have the disciplinary action. So an employer is bound to take disciplinary action against persons who have indulged in such inappropriate behavior. Then we have preventive steps. As I said earlier, the preventive steps has been once again uh, elaborated here with a certain definition, like you have to do so and so, there has to be a redressal and you cannot victimize the person anymore and all the likes. Then we have a complaint mechanism. Obviously, if there is a complaint, there has to be a mechanism to work out how it goes. So the code laid down a detailed mechanism on how to file a complaint, which I'm not elaborating right now because that shall be dealt in the future sessions and we're very short of time. Then we have the complaints committee. We know that it is a very commonplace system to bring about a complaint committee or an internal complaints committee, and all of these has been brought about as an aftermath of the Vishaka judgment. And again, this is dealt in detail by the upcoming speakers. I'd like to move on. The next point regarding the Vishaka guidelines is awareness. You have to spread awareness as to what constitutes sexual harassment, what action has to be taken, what remedies you can apply. So that is another aspect of the Vishaka guidelines. Then another part is when sexual harassment occurs as a result of an act or omission by any third party or outsider, then the employer and person in charge shall take all steps necessary and reasonable to assist the affected person in terms of supportive and preventive action. Then the next one is that the central or state government shall lay down the guidelines and ensure that it is also observed by employees in the private sector. Then, further, the final concluding point is that these guidelines do not prejudice any right available under the protection of Human Rights Act of 1993. I hope all of these guidelines, these 12 guidelines are clear. Can I please get a confirmation from the participants so that I know that all of you are here? Someone, please.
Yes, ma'am.
Yes, ma'am.
Yes.
Okay, thank you so much for that interaction. So if that is clear, we can move on to the I see hands being open. Is there a query? We can address the queries towards the end. So I'm just ignoring that for a while. So I'll move on to the next half of my session. So this is the final half, and after that we can have an interactive Q&A session. So the scope and application of the act. So we're talking about the POSH Act here. So firstly, there are 2 points I would like to enumerate regarding the scope and application, which is employer and workplace. So these are the 2 essentials of what constitutes a POSH Act. Since POSH Act means prevention of sexual harassment at workplace, obviously, so we have to define what is a workplace. Okay. So for that, firstly, we have to define what an employer is, because if there is only an employer, then there is a workplace. So there are 1, 2, 3, 4 guidelines which define what an employer is. So who is an employer? Can anybody read out the first one? Anyone participant? Can you please volunteer and read out the first paragraph, please? Somebody coming forward?
Yes, ma'am.
Okay, thank you. Can you read out the first paragraph?
Yes. Employer means in relation to any department, organization, undertaking, establishment, enterprise, institution, office, branch, or unit of the appropriate government or a local authority, the head of that department, organization, undertaking, establishment, enterprise, institution, office, branch, or unit, or such other officer as the appropriate government or the local authority, as the case may by an order specify in this behalf.
Okay, thank you. And can another person read the second sub point? Somebody?
Yes, ma'am.
Yeah, please go ahead.
In any workplace not covered under subsection 1, any person responsible for the management, supervision, and control of the workplace. Explanation: for the purpose of the subclause, management includes a person of broad or committee responsible for formulation and administration of policies for such organization.
Okay, and the third one, somebody else, please. Two more people to volunteer for the third and fourth. We'll make this quick. Can somebody come forward?
Yes, ma'am. In relation to workplace covered under subclauses 1 and 2, the person discharging contractual obligations with respect to his or her employees.
Okay, and the final one, somebody else once again. Last one, someone please volunteer quickly.
Yes, ma'am.
Okay, thank you, dear.
In relation to a dwelling place or house, a person or a household who employs or benefits from the employment of domestic worker, irrespective of the number, time period, or type of such worker employed, or the nature of the employment or activities performed by the domestic worker.
Okay, perfect. And thank you to the all four of you who had volunteered. So you can see that right now we have a very comprehensive definition as to what constitutes an employer. So you can see that the intention of the act is to ensure that every workplace is covered. So with the first clause, we have a huge definition, department, organization, undertaking, and you have a huge extension of enterprises, institutions, and all the likes. So that covers under the first half. And the second half, you can see that if any workplace is not covered under the subclause 1, then a person who is responsible for the management or supervision or control of such place is applicable. And then if it is a dwelling house, then so and so persons are applicable. So you can see that the term employer is covering the entirety of person who has authority. Okay, so we can see that the POSH Act is very comprehensive in ensuring to cover the ambit of the word employer. Now we move on to the final part, workplace. So can again few people volunteer to read. We'll have one person to read the first one. Please, someone.
May I?
Yeah, sure. Go ahead.
Okay. So am I audible?
Yes, you are.
Okay, so here you go. Workplace includes any department, organization, undertaking, establishment, enterprise, institution, office, branch, or unit which is established, owned, controlled, or wholly or sustainably financed by funds provided directly or indirectly by the appropriate government or the local authority or of a government, company, or corporation or a cooperative society.
Okay, great. And someone, can you deal with the second half? I'm sorry, but that wasn't very audible. Can someone else, please?
Yes, ma'am. Any
Okay.
private sector, organization, or a private venture, undertaking, enterprise, institution, establishment, society, trust, non governmental organization, unit, or service provider carrying on commercial, professional, vocational, educational, entertainmental, industrial, health services, or financial activities, including production, supply, sale, distribution, or service.
Okay, very good. So this is very brief. The rest few, so I can read that out. Hospitals or nursing home, any sports institute, stadium, sports complex, competition video, games venue, whether residential or not, used for training, sports, other activities, any place visited by the employee during course of employment, a dwelling house or a place. So we can see that again, the workplace is also very well defined under the Act. So you can say that essentially, if you take any one place, it is falling under any of this ambit. Okay, so if I am saying, say, I work at a cooperative uh, hospital, it is covered under the act of a workplace. If I say I am a household servant, it is again covered under the act under the dwelling house. And if I say I am a person who is working as an aya in a bus, it is again covered under the Act. So we can say that the POSH Act places immense importance upon the terms employer and workspace. Okay. So this is what the essential application and scope of the POSH Act is, and I'm not dealing with the rest of the implied detail of the POSH Act solely because the rest of the resource persons will be dealing, and I don't want to make this a bit monotonous. So this is mainly what the scope of the POSH Act includes with respect to the employer and the workplace. Okay, so I hope that is clear. And to say briefly about the POSH Act, you can see that the POSH Act is a very small act. It has around 30 sections divided into 8 chapters. It was enacted in 2013. So that is all about the POSH Act, and we have successfully covered our session. So with that,